Hi, Bill Chatt with the Cervantes Chat and Prince Legal Minute for Friday, April 24th, 2020. We are not doing our typical 1 hour webinar today. I'm coming to you from my bedroom, so hopefully the noise outside will stay at bay and I'll be able to get through this. I'll give you the quick updates on COVID-related news first, and then I'm going to go into my topic, which is, can we get out of that contract, force majeure, frustration of purpose, and commercial impossibility. I have the modified order from Governor Pritzker off to the side here on my screen. New essential businesses, greenhouses, garden centers, nurseries may open up as essential businesses. They have to maintain social distancing. Animal groomers, if Fluffy needs a haircut, can open up. As far as humans, I don't know that we are covered by this, and the way I read it, I really don't think so. There's probably too much close interaction there. So the new businesses are allowed to open up. Certain parks and golf courses can open up. Again, they're going to have to maintain some type of social distancing, which arguably I know the golfers were saying it's kind of built into it. Certainly at a driving range, you're not right next to somebody, but that's a little bit of good news. Maybe get rid of some of the log cabin fever that's going on around here. Face coverings, a lot of the suburbs were putting into place their own face covering requirements. Now it's statewide. So if you're out in public or amongst other people, you need to wear a face mask. For the essential businesses that were already open, the manufacturing, any of the essential businesses like trucking, if they can't maintain a 6-foot social distancing protocol, they have to distribute masks. So if you're in a closed setting, your employer, or if you are an employer, you have to somehow provide for that. Schools, if you have a kid at college and you need to empty out that dorm, if they can establish some type of procedure, that can go ahead. And I think that's pretty much it. It was no surprise. Mayor Lightfoot had actually kind of alluded to it, and you have to assume that the governmental officials, state and city, are usually in contact with each other to know that. Other news. The president is expected today to sign off on that second tranche of PPP funding. This is the Payroll Protection Program loan program through the SBA. So my understanding of where things were is that there's a lot of lenders that had people where they had done their part. The lenders are the ones that were doing the underwriting, the due diligence, and they were supposed to just hand it off to the SBA. So they had a lot that were in queue that were not able to get funded. Upon the president's signature, that will resume. I do see a lot of lenders are not taking new applications. You would have to check with the individual lender as far as that goes, if it's something you're looking into. The Economic Disaster Assistance Program and those $10,000 grants, that seems to still be down. I've got conflicting information on this. I've been told that it will not necessarily resume, but they're working on the third tranche, and that will be the time that will start up again. And I've also heard that that with this tranche there will be some. So this morning the SBA website still showed they were not accepting applications. So I'm going off that since they are the keeper of the funds. So right now I did not see that. That may change. If it does, we'll pass that information on to you. Okay, so for today's topic, it's entitled "Can we get out of that contract?" And what it is we're having a lot of clients of all walks, our business clients, our association clients. Doesn't really matter where people are saying, look, I've got a contract. We're going to build a house. We're going to have some service provided. That now, because of the shutdown orders and everything else, we would like to get out of the contract. Is it something, from a practical standpoint, we can do? Or maybe someone's got a venue for a spring event. It's always a spring event. And obviously, there's not going to be any spring events. Whether there's even going to be summer, fall events, no one knows. So you've got this issue where even if you wanted to go through with a spring concert, say at a venue, you can't. So we've got these clients calling. And of course, on the flip side, if you're the venue, you're saying, hey, well, we'll give you another date. So it sets up the issue. So again, it's can we get out of this contract? Force majeure, frustration of purpose, and impossibility. I've got a PowerPoint that I prepared for this, and so I've got these slides that I'm going to bring up. and we're going to go through them. And I will make these available on our website. So if you go to ccpchicago.com, which is on the bottom of that slide, you will see on our front page, we've got a link for video webinar archives and videos. And anytime we have documents to go along with these videos, we make them available there. So I will make these available for your download. So the first concept, and it's the most recognizable concept, is force majeure. This is the one that is, if you have a contract, you look for this clause. So the first step you might want to take before you call your attorney is pull out the contract and see if this is anywhere in there or something that is kind of worded this way. Force majeure sounds a lot like shrimp de jour, but it's much less delicious, but they both give you heartburn if you don't practice moderation. It's an event or effect that can neither be anticipated nor controlled. So far, so good. I think a worldwide virus that will kill you if you aren't careful probably could not have been anticipated or controlled. That's kind of what we're in right now. I want to stop for a second and caution you that the courts look at contracts, whether you're in a commercial setting or a consumer setting, differently. If you're a consumer, in a lot of instances, a mortgage refinance, a finance agreement for a car, for an addition to your house, for a roof through the roofing company, you have some protections there statutorily, typically a rescission, a 5-day right of rescission, or something like that, a cooling off period. Those are usually baked in via statute. Not always, but typically. So the courts look at it that way. There's also the Illinois Consumer Fraud Statute, where if someone's doing something fraudulent, the courts will rescue the unwitting consumer from the fraudulent behavior. So there's some stuff there. Commercially, the courts will say, look, regardless of the actual fact, we have sophisticated parties. Each side has access to counsel, accountants, whatever. They can go and ask a lawyer, hey, before I sign this contract, take a look at this. You can ask a lawyer to modify it, to make changes. So you have that access to the professional advice you need. And the courts will say, look, we're going to look at the contract as the parties wrote it. And again, you have access to it. The fact that you didn't, it's not going to change the analysis because you had the access. So we're going to look at the contract as written by the parties, and we're going to assume that they meant what they said. And we're going to look at the four corners of the contract, and we'll just interpret it that way. Not to say that if something is unclear or ambiguous or something's missing, that the courts won't fix it, but they're not going to save you from things that are clear and understandable. So with that said, force majeure typically needs to be expressly baked into the contract. You typically have to have a paragraph that says force majeure, and you're going to have some language like I've got here. Here's an example. Neither party will be liable for any failure or inability to perform or delay in performing such party's obligations under this agreement if such failure, inability, or delay arises from an extraordinary cause beyond the reasonable control of the non-performing party, provided that such party diligently and in good faith attempts to cure such non-performance as promptly as practical. So if I'm the contractor and for some reason, because of right now, contractors seem to be essential businesses. Let's go to the venue. It's probably a better example. I've got a venue and you wanted to have your spring concert. I can't let people in. There's no large gatherings. So if you're trying to push your event, which is usually the flip side, I can't let you do it. So I am excused from performance under the situation we're under right now. The problem with these clauses is I have to admit that it's typically where you hear that term boilerplate. Attorneys have this clause sitting in the first contract they wrote out of law school, and it's cut and pasted, and it's not necessarily very specific. If this clause had in there, including but not limited to war, acts of God, acts of government, episodes of pandemic, if that was in there, you really could point to it and say, look, there's a pandemic going on. It's in the contract. It makes the lawyers and the judges' life much easier because we specifically provided for that. But again, in this situation, I don't think it's fatal. I did a CLE, continuing legal education webinar on Tuesday, and we were discussing this. And the thought process is here in this first go around, courts and judges will probably be a little more willing, and there's no guarantees, but a little more willing to open up the rough edges of the definition and say, look, this pandemic counts. But years from now we know that there are viruses out there that can shut the world down, and governments will do it. The courts might in the future say, look, you got to put that in there specifically. Again, back to the commercial analysis versus the consumer. You need to say it. You need to say what you mean in that commercial contract. And that's why I have so many, typically handles what happens with contractors. Oh, I like a simple contract and all that. Okay, it's great. I'm sure your customers love it. When you need to come to me on a specific issue and it's not there because you want a simple contract, it will be construed against you, because courts, to the extent it's your contract, so if you're the one that just has this thing that says sign here, the court will say that's your contract. We're going to construe the fact that it's not there against you. So there's an example of force majeure language. So let's go on to the next slide. So I think I just said this, that certain clauses delineate specific force majeure events. So that's what you want to have. There's specific, much better. Some are more generally defined as act of God's, events out of parties' control. And then you're going to have to allow the court to try and put that in there. So the courts aren't going to necessarily look at whether or not something was foreseeable or not. That's not really their job. They're going to look to see if the clause was there. Foreseeability, what we're talking about is, let's say you put it in there, but no one thought it was going to happen. That's what we're talking about with foreseeability. Courts aren't going to engage in that. I mean, if you've got a well-written force majeure clause, you probably will get the court's favor on something like that. Now, the fact that you have force majeure written into your contract can be both a sword and a shield. We love that one in law, a sword and a shield. So whereas you're using it as a shield, it can also be used as a sword against you. What I'm saying is, because you have force majeure, the other two concepts that I'm going to talk about, frustration of purpose and impossibility, are not necessarily written into contracts, but they are affirmative defenses available to contracts. But what this says is the fact you got force majeure might preclude you from those other defenses. Again, until you get in front of a judge and find out, you really don't know. The next point, and this is case law that I'm kind of bringing out here. The next point is an interesting one. Performance may be permanently excused if the force majeure event is prolonged. At the start of this broadcast, I said that the mayor has now kicked out the impossibility, or I'm sorry, the stay-at-home order to the end of May. So if that's the case, it's been prolonged. So now you're getting closer to getting out of the contract entirely. My example of the spring concert, there's only one spring right now in 2020. So as we pretty much can write off anything happening in spring, people with those type of contracts and those type of situations have a better chance of probably getting out of their contracts entirely. If it's something that can be delayed and there's no real harm to the parties, I would not be surprised if the court would say, no, you don't get out of it totally. You might not have to pay him right now because he's not doing the work or whatever. But I don't know that you would necessarily be able to get out of it entirely. This is an example, not necessarily here. Change in cost is generally not a force majeure event. This came up a lot in 2008, 9, 10 during the real estate crash. There was a law firm going around town on behalf of developers, had a real interesting way of trying to get a contract saying, look, because of the real estate crash, the money I said I was going to pay you for that really prime piece of land in the loop, it's no longer worth that. And, we should be able to get out of the contract. Didn't work. So change in cost, which is not necessarily what we're talking about with the pandemic, is not going to get you out of a contract. Okay, so now let's go to the less used and not necessarily expressed written clause or defenses to a contract. The first is frustration of purpose. The definition is where a contract is made, a party's principal purpose is substantially frustrated without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made. His remaining duties to render performance are discharged unless language or the circumstances indicate to the contrary. So there was a basic premise that you'd be able to have your spring concert, that there would be no intervention from government, there would be no way that people would not be allowed to gather. So now we say, well, we don't have a force majeure clause in our contract, but here's a premise that we didn't think that the world would be shut down. Now it is, therefore we're going to try that. This is not something you would typically see written in a contract, but you would say, look, it's not written in the contract. Nonetheless, this is why we should be able to get out of the contract. Here's an example. Customer contracts with the fire protection company to install a fire protection device in the building because the municipality passes an ordinance requiring the device. Before any work begins, the municipality rescinds the ordinance because of questions of the device's effectiveness. You sign a contract with the fire protection company to put this device in. City comes, hey, we're not going to require it because apparently this thing doesn't work. That would be an example where I would think the court would say the frustration of purpose applies here, because the premise was that the city was going to make you put it in and it's going to do what it's supposed to do. Now you might necessarily be contracting for a device that doesn't work, that's not required. So there you would think that you might be able to get out of it. Again, a lot of this stuff I'm talking about, it's, we've got case law. You see me when you see the name of something that's underlined, there's numbers. That's I'm stating a case there for the non-attorneys out there. This is where we're kind of getting our information from. But it's not necessarily a concept that is set in stone as much as other concepts within contract law. So frustration of purpose or commercial frustration as the doctrine in Illinois is a defense, but it's not to be applied liberally. That's a direct quote from the court saying, yes, it's a defense, but we're not just going to give you get out of jail cards free. So again, where the courts can look to the contract and say, look, there was the delay of a month or 2 months, whatever, you didn't pay the money, but they're still willing and able, and you pretty much are still going to go through with it. Certainly not a defense to switch contractors, to switch parties in contract. That for sure would really get a lot of scrutiny from a court, where you say, well, we want to get this contract because of what's going on with the pandemic, but 3 months later, we're going to go ahead and bring another contractor in to do the same thing. I got it cheaper or whatever. It's not going to be a chance to do that. So again, the courts are not going to be handing these out like breath mints, just so you know. Continuing with frustration of purpose. The doctrine requires that the frustrated purpose be so completely the basis of the contract, again, my fire protection example, as both parties understand, without it, the transaction would make little sense. It would make little sense to enter a contract for a device that doesn't work, that the city no longer requires. Additionally, the frustration must be so severe that it is not fairly to be regarded as within the risks that the party seeking rescission assumed under the contract. Lastly, the non-occurrence of the frustrating event must have been a basic assumption on which the contract was made. So again, really going to the relevant issue at hand, the pandemic is not something that anyone could have seen. And in the instances of where gathering of people is that issue, it's that purpose to me is frustrated. You can't do it. Another little sidebar is a lot of people with season tickets for sporting teams are starting to say, hey, it's looking like we're going to have, if we do have games at all, we're going to have them without spectators. I paid the money in advance. What are we going to do here? Which a lot of teams, what they like to do is they like to say, oh, we'll put it on your account for next year, which we all hope there will be a next year with sporting events and things like that. So again, you see where it really has to be kind of absolute. I think the COVID pandemic is an absolute. It just depends on what your contract that you're trying to get out of would be. So where with this COVID pandemic, where there is no express force majeure clause, the frustration of purpose may offer some relief from the contract. Again, consult with your attorneys. I would not go it alone, because this is a concept where you really have to look at the case law. Not being able to pay for the contract, say in the event of a condo association, collections are down, we just don't have the money. That's not necessarily an example of frustration of purpose. So again, that's something where you might want to talk to the vendor that you're dealing with to see if you can come up with some kind of solution. Okay, the final concept is impossibility of performance. Factual situations where one party to a contract finds that the purposes for which a contract was made have become impossible to perform on one side. Again, that's some case law. An example, someone signs an engagement letter with an attorney who shortly thereafter loses their license and can't perform their services as an attorney. Don't know this situation, totally made up. But you certainly couldn't come to that attorney and say, I want you to nonetheless be my attorney and perform those services, because that is, you're barred from doing that. That would then be an unauthorized practice of law. Conversely, the attorney not having earned any of the money for the services. If he had a retainer, he'd have to give it back because he can't perform the services. It's impossible. The doctrine excuses performance where performance is rendered objectively impossible due to construction of the subject matter or the contract by operation of law. If I'm going to rent your venue from you to have my spring concert and lightning hits it and it burns down to the ground, it's not there for you to rent to me. So you are excused from the performance. I can't sue you necessarily for breach of contract. Again, you don't get to keep the money, but you can't perform by giving me the venue. Reading on possibility of performance is limited to the destruction of the means of performance by an act of God, vis major, nice Latin term, or by law. Performance of contract only excused under doctrine of impossibility when it's objectively impossible. So the third party here, the judge, is going to say, yes, that is impossible. This doctrine has been narrowly applied due to in part to judicial recognition that the purpose of contract law is to allocate the risks that might affect performance, and that performance should be excused only in extreme circumstances. So again, back to the business parties versus the consumer contract setting, the courts are going to say, you guys should be thinking about this stuff. Now, that type of analysis seems to be more like when you're writing contracts for services at a nuclear reactor. You know there's certain risks here, or you're going to go skydiving. You know, you can do a company out of skydiving, where that risk is real obvious or can be covered and discussed. The court's going to look at it that way. If the parties just decide to turn a blind eye to risks that are typical in their business, the courts will say, hey, you know what? No, we're not going to allow it. And again, you'd have to take it from a case-by-case basis. The party advancing the doctrine must show that the events or circumstances which he claims rendered his performance impossible. So if you're the one using this as the defense, you know, in other words, trying to get out of the contract, it's going to be up to you to put on a very good case as to why your performance is impossible. So those are the three concepts as you are sitting here looking at various contracts that you may have issues with, whether performing now or later, that these are the defenses that are available to you. The force majeure, which is typically something that needs to be written into a contract, and then the ones that are not necessarily written in contracts, frustration of purpose and impossibility. So whether you're a vendor getting calls from customers looking to get out, or you're the customer looking to get out, these are the three things that are available. They're out there. There's case law on it. And as always, you should consult with your attorney on this to make sure that the facts match up with the situation you're dealing with. Certainly the pandemic that we're dealing with now brings up these three concepts. So thanks again for tuning in. We will be back on our normal webinar schedule next Friday, and watch for the announcements, and take care of each other and be well, and we'll get through this. Thanks.